Barring adjournment of MC Singla case at the Supreme Court on December 17, this podcast appealed to the government and the Supreme Court of India to let justice reign on 8 lakh retired bankers whose dignity in old age depends on updation. I'm Nisha Bhattacharya and my co-host is Priya Chakraborty.
And we're talking about senior citizens, many in their 70s or 80s, the very elders who built India's modern banking infrastructure branch by branch. Now they live on a frozen pension ravaged by inflation and time.
These bank elders, the unsung heroes whose expertise and diligence underpin today's India's world-class financial sector. Sadly, the role of honor of e-bank retirees like DS Nakara and MC Singla continue to fall.
And on 17 December, members, the remaining super seniors and their unions are taking the fight to the union and IBA. They're fighting for pension updation, a basic right that other central government retirees take for granted.
That number, 8 lakh senior citizens, it just gives you the sheer scale of the issue. Today, our podcast is a humanitarian appeal to the government and Supreme Court of India to give bank retirees the justice and dignity they deserve in old age.
And our podcast, it really synthesizes the entire legal history, the administrative roadblocks, and the core humanitarian crisis that's driving this demand.
Yeah. So they're watching inflation, the cost of healthcare, all of it just soar while their income is completely, totally static.
It's a crisis by erosion, isn't it? So, our mission today is to give you a deep dive into this appeal. We need to unpack the statutory basis for their claim. I mean, where does the law actually say they must receive this updation?
We also don't need to identify the 3 institutional groups that are allegedly opposed to the award of updation. And finally, we'll explore the crucial judicial precedent that retirees argue has destroyed the government's primary defense.
It's not just a moral argument, it's a very detailed legal and administrative challenge. We really have to treat this as an investigation into statutory duty versus bureaucratic delay.
Okay, let's unpack this. We have to start with the legal foundation for their demand. This all seems to hinge on the Bank Employees Pension Regulations, which came into force back in 95.
Specifically, Regulation 35 of those regulations, the BEPR. This single regulation is the cornerstone of retirees' entire argument, and it is remarkably clear.
Regulation 35 to 1T doesn't suggest, it mandates. It states that basic pension and additional pension, and I'm quoting here, shall be subject to revision whenever the pay structure of serving bank employees is revised.
An explicit statutory link. Every time the current staff get a pay hike, which happens regularly through these settlements, the retirees' pensions must also be revised proportionally.
So the law is not ambiguous at all. Says if current employees get a raise, retirees get an update. But when we look at the human cost, the sheer magnitude of the financial disparity is just staggering.
It is. We're talking about senior citizens, many in their late 70s, 80s, with critical medical needs, and the financial gulf between retirees is enormous. As much as 40% to 60% for a 1995 to 2005 retiree compared to a 2010 retiree.
And they could have had identical years of service, same roles.
Exactly. Service. And that gap, that 40 to 60%, it doesn't just represent a loss of savings, it represents a significant loss of quality of life and access to healthcare.
Right? And this brings us immediately to the principle of parity, which is a constitutional issue, really. Why are they fighting this battle when their peers in other public services aren't?
That's the key question. For instance, pensioners from the central government, the RBI, and the Life Insurance Corporation, or LIC, they all enjoy routine regular pension revisions.
Their pension is keeping pace with the salary settlements, but the retirees from the public sector banks, the PSBs, remain excluded. And that disparity is being framed as an unconstitutional failure to uphold equality.
So it's a violation of their rights.
It is. Disparity directly violates fundamental constitutional rights. We're talking Article 14, the right to equality, and Article 21, which includes the right to life and dignity in old age.
And, the dignity of old age is paramount here. If you treat two classes of public servants who perform the same duties differently, you create what the courts call an arbitrary and unequal classification.
And what's interesting is that this expectation of parity, it wasn't just invented recently, it was actually baked into the foundational agreement.
That's a critical historical point. When the pension scheme was first set up, The 994 minutes from the small committee on pension, this was the IBA and the unions, explicitly agreed to use the formula along the lines of RBI pension updation scheme.
So the RBI was the model from day one. This historical foundation shows the expectation was always to mirror the RBI's approach. That original promise is now the basis for claiming persistent discriminatory neglect.
Okay, so we have a clear statutory obligation in Regulation 35(1) and a historical intent for parity with the RBI model. If the legal foundation is so solid, why hasn't this happened? This suggests the breakdown is administrative.
Right? And the appeal identifies what you could call a triangle of institutional obstruction.
Yeah, if the system worked as it should, the IBA would propose the changes, the government would approve them. Simple. Instead, we have three distinct entities named as barriers to updation.
Let's start at the top. The government, or specifically the DFS, what is their role in this?
The DFS, Ministry of Finance Department, is the ultimate approval authority. The charge against DFS is that they have been withholding approval for the IBA's proposals since 2019.
And their reason? They cite inflated financial liability that this revision would supposedly create. And how do the retirees counter that?
Well, the DFS views this not just as a cost to the banks, but potentially a systemic economy wide fiscal issue if other sectors demand the same thing. That's the contagion effect we'll get into later.
The fear of opening the floodgates.
Precisely. But the retirees argue that this fear of cost is just an excuse for economic discrimination. They assert the actual financial burden is misrepresented and, crucially, that bank pension funds are segregated and often actuarially sound.
And it brings us to the second player, the Indian Banks Association, the IBA. They're supposed to be the body that initiates these proposals. Where are they failing?
Many retirees accuse IBA of non transparency, specifically of using actuarial assumptions that grossly exaggerate the total pension liabilities.
That's the claim. It makes the financial problem look larger than it allegedly is, which then gives the DFS a strong hook to deny approval.
So, the alleged accusation isn't just that the IBA is slow, it's that they are actively inflating the numbers.
Furthermore, the IBA is also criticized for overstepping its advisory authority and for ignoring Supreme Court rulings that prohibit creating two separate pay scales, one for serving employees with updation and one frozen scale for pensioners.
So, you can't have two different systems, they had to be linked. That's a powerful indictment. Now, let's move to the third group in this triad.
Unions, the United Forum of Bank Unions, the UFBU. Why are they being criticized by the very people they once represented?
Well, the UFBU is criticized allegedly for a failure of solidarity. The retirees feel the unions are focusing almost exclusively on current employee settlements, like in 11th bipartite settlement.
And rightly too, retirees felt abandoned by the organizations they helped fund and build, and they feel betrayed.
Understandably, 8 lakh retirees now want a seat at the negotiation table, direct representation in all future talks. They want parity with UFBU.
Okay, so we have a statutory mandate being stalled by what they call administrative evasion and representational failure. Now let's pivot to the legal artillery the retirees are deploying. This is where it gets really interesting.
This is where the legal theory shifts from what the regulations say to what the Constitution demands. And the most important pillar is a 1983 Supreme Court ruling on DS Nakara and ORS. V Union of India.
It fundamentally redefined the nature of pension in India. It established that pension is not a discretionary payment or what the court called a bounty. It's a fundamental right. Deferred wage for past service.
The idea is when you work, part of your potential salary is deferred until retirement, and that deferred pay should retain its value.
So if it's a deferred wage, freezing it for decades is essentially stealing its value through inflation.
Precisely. Denying updation violates this fundamental principle. It creates a system where the value of your compensation is artificially eroded based on policy decisions, not on your legal rights.
It also addressed date-based classification. If it's a deferred wage for the same job, it shouldn't matter if you retired in 1995 or 2010.
The appeal hammers this point home. Courts have repeatedly struck down these artificial classifications where retirees who did the same duties, contributed to the same fund, are put in unequal groups just based on their date of retirement.
It's deemed arbitrary because it lacks a rational nexus, as the courts say, which is to provide security in old age.
But let's go back to the DFS's favorite defense, the financial burden, the contagion effect. What does the law say about that?
The legal argument to DFS's administrative defense was crushing. The Nakara ruling explicitly stated that the plea of financial burden or administrative convenience cannot be a valid defense to deny equality.
The court said that if a constitutional right to equal treatment exists, the state must honor it. Cost is not a justification to violate the Constitution.
And we have to remember the statutory weight here.
The 1995 bank pension regulations aren't suggestions, they are subordinate legislation. They have the force of law.
Any action by the DFS or IBA that conflicts with Regulation 35, like refusing the mandated updation, is legally invalid. Mere circulars or internal policy can't override a regulation. That action is ultra vires beyond their legal authority.
So the legal case seems overwhelming. You have the statutory obligation, the constitutional mandate for equality, and precedents rejecting the main excuses.
But the real challenge to the DFS defense came from their peers at the Reserve Bank of India.
The RBI precedent from 2019 was a game changer. It directly challenged and defeated the DFS's core objection in court.
How did that unfold?
So, when the RBI pensioners sought their updation, the DFS mounted its defense, the same one they used against the PSBs. They explicitly opposed it because they feared the contagion effect.
The same argument?
They said that granting the RBI update would trigger demands from public sector banks, causing systemic fiscal issues. It was a direct test of their main defense.
And what happened?
The Mumbai High Court decisively rejected the government's plea. The court ruled once again that the fear of a ripple effect is not a valid legal reason to deny a right guaranteed under the scheme.
So, the moment the DFS lost that argument, their legal position against the PSB retirees became precarious.
Exactly. Following that judicial rejection, the government had no choice. They approved the updation for eligible RBI retirees in March 2019, and they used an actuarially determined multiplication factor that bank retirees now demand.
So, this precedent establishes some strong points against the DFS. What's the first one?
One, the contagion and systemic fiscal impact defense was legally overruled by a high court, and the government had to comply.
Okay, and point two.
Two, it proved that updation is administratively feasible and fiscally manageable. The RBI case shows the financial excuse is invalid because the pension funds are segregated and self-sustaining. The banks hold the capital. No government budgetary support is needed.
And the third and maybe most important point for the PSB retirees.
That the PSB retirees, whose scheme was explicitly modeled on the RBI scheme back in 1994, cannot legally be discriminated against now. Their exclusion is rendered irrational by the fact that their peers received the update.
The very peers they were supposed to mirror?
Exactly. And to make it worse, RBI pensioners received a second update in 2025, widening that gap even further and making the PSB exclusion even more arbitrary and indefensible.
So, what does this all mean for the 8 lakh retirees today? This podcast appeal is basically arguing that there's no remaining legal, constitutional, or fiscal barrier. All that's left is bureaucratic inertia.
That's the core conclusion. The denial is cited as unconstitutional, discriminatory, and contrary to the clear mandate of Regulation 35-1. And the retirees aren't just waiting for a vague promise, they are demanding specific measurable action.
What are the specific demands?
Retirees request immediate implementation. They want the updation factors notified, which they say are already prepared based on the working RBI formula. They want the DFS to issue a firm direction to all public sector banks to comply.
Finally, they demand the IBA be instructed to prepare transparent, uniform, actuarial cost tables.
We wish bank retirees success and justice at the Supreme Court on December 17. Please like, share, comment, and subscribe.